Well, hello. My name is Graeme Fraser, and I'm partner and head of OGR Stock Denton's family team. And today I'm going to talk about TOLATA and what it all means. Now, TOLATA is highly relevant because cohabitation is the form of family that is most increasing in this country. And therefore, a lot of people find themselves in a situation where if they split up without being married, the ownership of their family home and how that will be divided can be a very great source of financial dispute. So there are two ways in which you can hold a family home, own it. Either it can be in joint names or it can be in sole names. Now, if the home is in joint names, this is very likely to define what you are both entitled to. There's a definition of either it being joint tenancy or tenancy in common. It's not always the case that you can define it, but it's a very good start. And the important thing is, if you're buying a property together, you should always pay attention to what you record at that time. But if your name is not on the deeds, that doesn't mean that you won't get anything at all, but you may have to make a claim to share in your family home by demonstrating what's called a beneficial interest in the home. If you have something called a declaration of trust, which is a signed and witnessed document, or a living together agreement, this is going to be the best way to show that the non-owning partner is entitled to a share in the property. But if you don't have such a document, and you can't agree what shares you and your partner that you weren't married to have, then you're going to have to make a claim under TOLATA. That's short, the Trust of Land and Appointment of Trustees Act, 1996. If the person who doesn't own the property in what's called a sole ownership case has made significant payments towards the family home, and that can include making mortgage payments, and it's also shown that there was a joint intention, that's an intention by both of the cohabitees, that this would result in them having a legal share, which is then in turn called a beneficial interest, this might be enough. So if you don't have a formal document, it is difficult to demonstrate a joint intention. However, if you clearly discuss that matter with your unmarried partner, and you can then show that you were being promised a beneficial interest and you had made a financial or other contribution to the family home on that basis, then in those circumstances, the court can infer there was an agreement. Now, I have to say that that is a very difficult thing to grasp or explain, not just for the public, but also for lawyers. And I demonstrate that by the fact that there have been over 10 different indications just in the Supreme Court alone as to what that means. I think I've made the best job of it in explaining it in the most basic way possible. But I should say that TOLATA is a very complex area of legislation, and therefore it's vital to get early legal advice so that you can understand whether and how you need to take action. What a family lawyer can do is to discuss with you whether you can actually prove that you have a beneficial interest in the home, and in doing so, you should provide your lawyer with as much information and relevant paperwork as possible. If you can adopt a focused, sensible approach with guidance from a family lawyer, that can help resolve the dispute without going to court at all. And it's certainly true that going to court is very expensive, risky, and uncertain. And therefore, we would always try and look at solutions that avoid having to go to court. Now, as a specialist family lawyer, we can advise on alternative methods to resolve disputes. And that includes mediation, which we are able to operate from our offices, collaborative law. I'm an experienced and trained collaborative lawyer with many years of experience of that, and arbitration, again, another facility that we offer. Those processes are actually preferable in achieving an outcome that both you and your former partner are likely to consider fair, as well as often being cheaper and quicker. It really does pay to get the most efficient solution that costs you the least money to get the outcome that you want. Now, I belong to Resolution, the National Organisation for Family Law Professionals, and I'm actually chair of the Cohabitation Committee. And as part of that role, I help to develop practice, training and policy in this issue. And what we're really looking to do is to seek to minimise confrontation in family law. And you can find specialist family lawyers by looking at their website. Going to court is stressful, expensive and slow, and the outcome may be very uncertain indeed. So you should really only consider doing this as a matter of last resort. It's worth knowing that unlike other areas of family litigation, if you lose your case, you might have to pay some or all of your ex-partner's legal costs. So the difficulty with that is that you need clear, early legal advice so that you don't run that risk. Even writing a letter in reply to a letter before action could hold consequences. So you do need to get very early specialist legal input. Running a TOLATA claim is also complex, and it does pay to use a specialist family lawyer to help you through this. I can tell you it's complex because I have edited the second edition of Resolution's Cohabitation and Claims book, which contains about 12 chapters about how to do this work, even in simple terms. Before you start on a TOLATA claim, you will need to be in a position to exchange enough information so that you can understand each other's position and try to reach a settlement. There are three main stages in a TOLATA claim, which include what's called disclosure, inspection and evidence. This is all managed by the court throughout, but if you can't settle your case, you will then have a trial where you will be expected to give written and live spoken evidence, otherwise known as testimony. It's best to try and reach settlement without going to trial in most cases, because there is risk, uncertainty and cost, both in terms of money and time, if you go to trial. Cross-examination is never an easy or pleasant experience, but sometimes it is needed. Disclosure requires both you and your partner to reveal what evidence you have, and you have the duty to tell what is good and what is bad. This obligation continues until the end of the case, and it will require a reasonable search for documents and a disclosure of a proportionate level of papers. There's then a process of inspection, which means viewing the disclosure so that a decision can be made about which documents will be needed. During a TOLATA claim, there's a large amount of strategy deployed upon which you do need legal advice. This includes settlement offers, which are also known as Part 36 offers. These are offers to reach settlement which need to comply with certain rules. There are cost consequences, because if they are refused by the party to whom the offer is made, it can mean that you would receive an adverse costs order if you refuse it. But it is dependent also on the ultimate outcome of the case. What happens here is that the offers will not be shown to the trial judge during the trial, but they will be discussed at the end of the trial when the judge considers who should pay the costs. If you adopt a Part 36 offer, it's a useful means of attempting settlement without compromising the strength of your case. That is something a lawyer really can advise you on. The other things to just be aware of is if you are experiencing domestic abuse or violence, you may be able to get legal aid in certain circumstances. But be aware that domestic abuse in itself and the use of TOLATA, you're only likely to get legal aid for occupation and restrictions on living arrangements, and that won't include resolving ownership of the family home. The other work that we do, in addition to TOLATA work, will be financial claims in respect of children in certain cases. It's vitally important that you speak to your specialist family lawyer about that, because we can advise in situations where you may get financial provision in terms of capital or the transfer of a home while the children are growing up. it's very clear to us that TOLATA claims are time-consuming, expensive and risky, and you're much better off avoiding them in the first place. If you think about these things when your relationship begins or when you purchase your family home, you can avoid them. If you buy a home together, make sure you give clear instructions to the people who you've instructed, your conveyancers. If one of you already own the home, then it's best to enter into an express declaration of trust before the other partner moves in, so as to clarify what is intended as to beneficial ownership. We always recommend that people have a living together agreement set up, as that avoids future disputes with your partner. They're relatively cheap to have drawn up, and they provide a great deal of clarity and should be done when the relationship is going strong. And the other thing that you should always consider doing is making wills, because then you can have clarity as to what happens if the unfortunate unexpected happens and one of your partners and your partner dies. So that's really a nutshell guide to TOLATA claims. We are very much specialists in our field at our firm, and we would be delighted to help you on any queries you may have. Thank you very much.